Test, does it work? Okay. Good evening and welcome to the Stearns County Board of Adjustment public hearing for July 28th, 2022. And if I'll have you please stand for the Pledge of Allegiance as we begin our business. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, I have a couple of announcements to make. If you're in possession of a cell phone or other type of electronic paging device, I ask that you put it on silent mode at this time. Also, please note that all testimony is being tape recorded for this event, and if you're going to speak, you'll be asked to state your name and address for the public record first, and then go ahead with your input after you've been recognized by me, the chair. Members of the Board of Adjustment are appointed by the County Board of Commissioners with one member from each of the 5 commissioner districts and one member at large and one member appointed from the Planning Commission. I'm going to give a brief overview of our proceedings this evening. I'll read out the variance request and open the public hearing. While I'm reading your request, I would ask that the applicant or their representatives come forward and have a seat in front of the board by the microphone. The applicant and or their representatives will be asked to state their name and address for the record. Environmental Services staff will provide a brief overview of the requested variance, the staff report, and if any correspondence has been received regarding the request. The applicant and or their representatives will then provide any input, corrections, concerns, or comments. Once the applicant and or their representatives have provided their testimony, the board will discuss the request and ask questions of staff and or the applicant. Upon completion of the board questions, I will ask if there's anyone in the audience wishing to speak to this request, and if there is, I'd ask that the person come up to the podium, state their name and address for the record, and then give their testimony. When all testimony is complete, I will ask the board members for a motion to close the public hearing. Once the motion is passed to close the public hearing, there will be no further input from the audience, from the applicant, or Environmental Services staff unless recognized by the chair or if one of the board members wants some type of clarification. The board will review and discuss the findings of facts, and the facts are a series of questions that the board is required to answer based on Minnesota statutes and requirement of the ordinance. Based on the answers of those questions, the board will either grant or deny the variance request, and all questions must be answered in the affirmative by the board. Once the findings are complete, there will be a motion to approve or deny the request based upon those findings. And so with kind of our general overview finished, we'll move now to item number 1 on our agenda this evening to consider a request from Todd Robin, Sartell, Minnesota, from section 9.9.9A1 of Stearns County Land Use and Zoning Ordinance number 439 to add a roof-mounted solar array to an existing structure that is less than 120 feet from the center line of a road classified as minor arterial. Affected property is 1.6A, south 300 feet of the northern 900 feet when measured at the right angle to the north line. East are 233 feet of government lot 3, west of the center line of Highway 1, section 33, and that is in Brockway Township, and the property address is 38463 County Road 1 in Sartell. And if the representatives for that can please come forward.
Mr. Chair, Angie Bergen, Environmental Services. We can certainly table the request until later in the agenda, and I can step out and call the applicant and see if they plan on attending. And if they're not, we can still move on the request unless you had any particular questions for the applicant.
Okay. Do we need to have a motion to table that then, or just move forward?
You can just go on to the next one.
Okay.
Then.
With that, we'll table number 1 for this time. We're moving on to agenda item number 2 then, to consider a request from Adam and Samantha Fry, maybe, of Richmond, Minnesota, section 6.21P, table M of Stearns County subsurface sewage treatment system ordinance 422 to locate a subsurface sewage treatment system soil treatment area less than 100 feet from an ordinary high water level of a lake classified as recreational development. Affected property lot 15, block 001 of Singing Hills Plot 2, section 25 in Munson Township, and that address is 19533 Florence Circle in Richmond, Minnesota. And if the applicant there could please come forward. And then can I get your name and address for the public record, please?
Yeah, my name is Adam Free, address is 19533. Hi, my name is Adam Free, address 19533 Florence Circle, Richmond, Minnesota.
Thank you so much. And then a question for our board members for the record was who was able to make it out to the meeting? Okay, and then all except for, yep, okay. Environmental staff, to your report, please.
Thank you, Mr. Chair. A question for the board. Has there been any communications with the applicant or others regarding this application?
Yes,
I spoke to his wife when I did the site visit. She showed me where the proposed layout was or where it was going to be located on the lake side of the house.
Okay.
he did the same for us when we were there.
Okay. Thank you. On to the staff report. The applicant is requesting a variance from section 6.2.1P, table M of Stearns County SSTS ordinance number 422 to locate a SSTS soil treatment area 50 feet from the ordinary high water level of Cedar Island Lake classified as recreational development. Said ordinance requires the soil treatment area to be located at least 100 feet from the ordinary high water level of a lake classified as recreational development. The applicant currently owns Lot 15 of Block 1 of the Singing Hills Plat 2. The Singing Hills Plat 2 is in Munson Township and was platted in 1977. The parcel is in the Shoreland Overlay District of Cedar Island Lake, which is classified as recreational development. Cedar Island is on the list of impaired waters for nutrients and mercury in fish. The property is in the R1 zoning district and contains approximately 48,646 square feet of lot area above the ordinary high water level of Cedar Island Lake. The applicant obtained the property in 2022, and there is an existing 4-bedroom dwelling that was constructed in 1999 with a variance to be 90 feet from the ordinary high. The existing subsurface sewage treatment system was inspected in April of 2022 by an inspector licensed with the state of Minnesota and was determined to be non-compliant for failure to protect groundwater. The applicants have submitted a septic design completed by a licensed septic designer. The design specifies sewage tank capacity and soil treatment area size for a 4-bedroom dwelling. Munson Township, Sauk River Watershed District, Sauk River Chain of Lakes Association, the Minnesota Department of Natural Resources, and property owners within 500 feet have been notified of this request. And alternatives and recommendations are to grant or deny the variance as requested based on the findings of fact. We have not received any correspondence regarding this application, so I don't have anything else for you, Mr. Chair.
Thank you very much. And applicant, to your request, anything you wish to say to the board?
So we are requesting that we are able to install a new septic system to replace an old failing one that is no longer protecting the groundwater. We brought in a professional to design a system that he believes, and we are trusting his recommendation, that this system will be in the best interest of ourselves, somewhere we're going to be for a long time, as well as the community around us right now. Where the system is now, when we had all of that water earlier this spring, was, I believe the bottom portion was underwater, so I don't think it's in a tenable location any longer. Where we propose to move it is a lot further from any high water mark, so I think getting it up and not having any water infiltration is in the best interest of everyone, ourselves, as well as those who like to enjoy the lake.
Any questions from board members for the applicant and or staff? If there are no questions, looking for a motion to close the public hearing. Motion, can I get a second?
I'll second.
All those in favor say aye.
Aye.
Opposed, same side. All right, so now moving, isn't the light not on? Oh, oops. Now moving to our finding of facts, question number 1. The proposed use is allowed in the zoning districts in which the subject property is located, and an editorial note that since we do not have the full board member here with us, I will be abstaining from voting this evening. Question number 1, the proposed use is allowed in the zoning districts in which the subject property is located, yes or no?
Mr. Chair, yes, septic systems are allowed in that area.
All right, a yes. From George, is that the general agreement of the board? Okay. A yes for number 1. Number 2, the variance will be in harmony with the general purposes and intent of the official controls, yes or no?
Mr. Chairman, I'd say yes under the Lakeshore Living policies to address wastewater treatment and water quality problems.
Okay. We have another yes. Is the board in general agreement for number 2 is a yes? Okay. Number 3, the variance will be consistent with the comprehensive plan, yes or no?
Mr. Chair, Bonnie Mossman, I would say that the intent of the comprehensive plan is to protect the lake. And right now, where the septic system is not protecting the lake. And even though it's going to be close to the OHWL, where they propose to put it is a much better location than where the current one is located.
All right, we have a yes for number 3. General agreement of the board is a yes. Okay. Number 4, the property owner proposes to use the property in a reasonable manner, yes or no?
Having a septic system is reasonable use of a residential lot.
I think that would be a general agreement with the board. Number 5, the plight of the landowner is due to the circumstances unique to the property not created by the landowner, yes or no?
Mr. Chairman, I would say it's wasn't created by the present landowner because they just purchased property.
General agreement, yes for the board. All right. That's for number 5. Number 6, the variance, if granted, maintains the essential character of the locality, yes or no?
You won't see any change to the neighborhood. So I would say yes.
General consensus for a yes. Okay. Number 6 is a yes. Number 7, the need for the variance involves more than economic considerations, yes or no?
I would say, Bonnie Mossman, I would say it is a health concern in order to have a well-operating septic system.
All right, general consensus, yes for number 7 from the board. With that, all questions being answered in the affirmative, I'd be looking for a motion to approve the variances requested.
Mr. Chair, I'll move to approve.
Okay. From George. Second? Anybody?
I'll second.
Second from Dave. All right. The remaining votes, Bonnie,
Yes.
Rob,
Yes.
and Ken.
Yes.
All right. Therefore, the motion is approved. Congratulations. If you have anything that you need to talk to staff with, please do so during regular business hours. Thank you very much.
Thank you, board.
All right, moving on to number 3 then, and that is to consider an after-the-fact request from Mark and Michelle Lyons, Waverly, Minnesota, from sections 6.21G, 7.21, 7.221B, 10.211A of Stearns County Land Use and Zoning Ordinance 439, and section 2.1 of Stearns County Subsurface Sewage Treatment System Ordinance 422. To leave is placed and to relocate 2 permanent recreational vehicles on a lot with an existing principal structure less than 10 feet from the side property line, less than 75 feet from the ordinary high water level, and in the shore impact zone of Clearwater Lake classified as recreational development that are not served by subsurface sewage treatment systems. Also, to leave as constructed 2 residential accessory structures that are less than 10 feet from a residential dwelling unit. Affected property lot 002, block 001 of Coes, Clearwater, Augusta Pass. and that's section 11, and that is in Fairhaven Township, and the property address is 12588 Bayview Road in Clearwater, Minnesota. And if the applicants for that request could please come forward. All right, and if I can get all of your names and addresses for our public record, please.
Good afternoon. My name is Tyler Adams. I'm an attorney on behalf of Mark and Michelle Lyons. They asked me to come and speak on their behalf today. With me are Mark and Michelle Lyons themselves, so they can introduce themselves. My address for these purposes is 803 West St. Germain Street, St. Cloud, Minnesota.
Lyons, my home address is 1223 Estes Avenue Southwest. I reside in Waverly, Minnesota, 55390.
Michelle, can I have you do that again?
My name is Michelle Lyons. My home address is 1223 Estes Avenue Southwest, Waverly, Minnesota, 55390.
And I'm Mark Lyons. My address is 1223 Estes Avenue Southwest, Waverly, Minnesota.
Thank you very much. And then now to staff to our report, and then we'll get back to you.
Thank you, Mr. Chair. I'd like to ask if any of the members of the board have had a chance to visit the site. All right. And then I would also like to ask if there was any correspondence between members of the board and the applicants or others regarding this request. All right. Thank you. On to the request. The applicants are requesting a variance from section 6.2.1G, 7.21, 7.22.1B, 10.2.11A of Stearns County Land Use and Zoning Ordinance number 439, and section 2.1 of Stearns County SSTS Ordinance number 422 to leave as placed and to relocate two permanent recreational vehicles on a lot with an existing principal structure 0 feet from a side property line, 15.6 and 11.3 feet from the ordinary high water level, and in the shore impact zone of Clearwater Lake classified as recreational development that are not served by a subsurface sewage treatment system. Also to leave as constructed two residential accessory structures that are less than 10 feet from a residential dwelling unit. Said ordinance does not allow for any permanent RVs when one principal structure exists and requires RVs to be placed a minimum setback of 10 feet from the side yard outside of the shore impact zone, 100 feet from the ordinary high of a lake classified as recreational development and to be served by an SSTS, and for accessory structures to be 10 feet from a residential dwelling unit. For some background, the applicants currently own the north half of Lot 2 and all of Lots 3 and 4, Block 1 of Coe's Clearwater Augusta Passage in Fairhaven Township on Clearwater Lake. Coe's Clearwater Augusta Passage was platted in 1954. Excuse me. The property is in the Shoreland Overlay District of Clearwater Lake, which is classified recreational development. Clearwater is on the list of impaired waters for mercury and fish. The property is in the R1 zoning district, and the tract contains approximately 29,914 square feet in lot area that is above the ordinary high per county records. The applicants purchased the property in 2017 with an existing 696 square foot manufactured home and two permanent RVs. Aerial photos indicate that between 2005 and 2015, both RVs were brought in to replace existing RVs in the same location. The SSTS, a holding tank that services the existing dwelling, was permitted and installed in 1996. A compliance inspection was completed on the tank by a licensed septic inspector in August of 2019. The system was certified compliant. An alternative to the request would be to remove one RV and relocate one RV to an area of the property that meets setbacks for no more than 30 days in a calendar year to meet the requirements of a temporary RV provision of the Land Use and Zoning Ordinance. A provisional use registration would be required. Fairhaven Township, Clearwater Lake Property Owners Association, Clearwater River Watershed District, the Minnesota Department of Natural Resources, and property owners within 500 feet have been notified of this request. And Alternatives and recommended conditions: grant or deny the variance as requested based on the findings of fact. And then an alternative would again be to remove one RV and relocate one RV to an area of the property that meets setbacks for no more than 30 days in a calendar year to meet the requirements of the temporary RV provisions of the land use and zoning ordinance. A provisional use registration would be required for that. We have not received any correspondence at the county regarding this request.
Thank you.
That's all I have.
Mr. Chair, before you move on to the applicant, Deb in the control room was asking you to please repeat who visited and the site and who makes the first and second motions. We need a verbal,
Okay.
not just head nods.
Okay.
Please.
Very good. So all those that, Rob, did you visit?
Yes, I did.
George?
No.
I did. Jake did.
Yes, for Bonnie?
I made the motion.
Oh, no, we're asking who visited the site.
Visited, yes, I visited.
And yes, I did.
Okay. And then motion for the last.
The last item, Mr. Chair, and I was out of the room, so I'm not sure who made the first and second, but a verbal on those, please.
For the motion and second to.
For the last request?
The last request.
I thought I said that out
For
loud.
freeze.
But I'm pretty sure I did, but that was George
Made the motion.
Made the motion.
Motion. I second.
and Dave did. It's the second.
I second it.
Yep.
Okay, thank you.
I said it out. Okay. All right, and applicants to your request and representative.
Thank you. Well, the request is quite a mouthful, but ultimately it's actually fairly simple. It's unfortunately what's being requested through this variance is something of a square peg in a round hole. The Lions aren't asking to build anything new. They're asking to be able to keep as situated campers that have been situated in that position on their property since at least 1985. The situation, as I understand it, is that the reason why the request has to be as complex as it is because there has been some ambiguity regarding the location of the lot line separating the Lions property, which is technically two different parcels. So the Lions have owned both of them since, I believe, 2017. The issue at hand is simply that one of the campers partially abuts onto the second lot, which causes the request to be such that the Lions would have to move it onto a couple of feet onto one lot in order to comply strictly with this particular variance request. The spirit of the variance request, again, is not to build anything new, it's to keep campers as they have been situated since the Lions purchased their property and for a great deal longer than before. As far as the factors that the board has to consider, in particular, the factor as far as keeping the character of the community, I would just remind the board that as of last year, the reason that this has become a point of controversy is that last year the board debated and passed a new ordinance as far as the maintenance of RVs on properties in Fairhaven area. And my understanding is the board heard a great deal of testimony from individuals who are concerned about things such as noise complaints, cluttering the area, a number of campers situated on private property that a lot of people thought should not have been. I would just point out that with these campers having been situated for 40 years, it would be somewhat incongruous to now say that they don't fit the character of the community or that they somehow no longer should be allowed to be there simply because the board has passed new resolutions regarding governance of recreational vehicles in Stearns County. I would also point out that towards the end of the Lions application, they point out the statute as far as county enforcement of new ordinances and non-conforming structures that previously existed. Now, obviously, I'm not here today to make any sort of legal argument to that effect. I would just point out the principle of the matter more than anything else. With the Lions' perspective, what's happened here is that the board has passed a new ordinance and it's caused all sorts of controversy over currently situated RVs because of new RV requirements. And, well, if that were strictly the case, that would raise potential constitutional issues as far as their rights as property owners not to have to modify their property because of newly passed rules and restrictions. To that end, I would just point out that the campers as they are situated do not have any particular negative effect on the community. The Lions are not the subject of the noise or cluttering complaints that gave rise to the concerns that the board discussed last year as far as having permanent RVs situated on their property. And as far as I can tell, there is no reason not to allow the campers to remain as situated, which is the reason for this variance request. Thank you.
Mr. Chair, Angie Berg, I just want to give a little bit of background. The County Planning Commission and County Board of Commissioners, Ken Mossman is still on our Planning Commission, was part of the group when we went through about a year and a half of various changes for the county ordinance as a result of our comprehensive plan. And as the representative's attorney stated, there were changes made last year. The changes were only to clarify what's allowed on certain parcels. The state statute that is being referenced, and I did point that out to the attorney, is for legal nonconformities. And there's a definition in the law about legal nonconformities, and it's something that existed prior to the effective date of the ordinance. The ordinance being the Shoreland Ordinance, which was adopted in 1972, not the ordinance that was just amended last year. There has ever and only always been one permanent recreational vehicle, cabin, or home on one parcel of record. So while I understand the statements and the arguments, I've had this conversation with probably over 100 people in the last year. This is was a controversial issue. We are really closing in on compliance on most sites. But we do have some, obviously they have the administrative right to apply for a variance and come in front of the board. So I just wanted to kind of give a little bit of background because Ken probably remembers all of those discussions that we had too.
Actually, Angie, I went back. I still have the old comp plan. I have the version from 2017 and the one from 2018. And in both cases, it says they're allowed a primary residence and no other RVs on the property. So this isn't something that just changed in our last 2 years ago or in the last year. This is something that's been since the 2010 comp plan was put together. So this has been for a long time. And the thing is, if we allow this to one person, then somebody else is going to come. This was the argument. Well, we want to have two of them, one of them or two of them sitting there, and somebody else. And yes, they've been there 40 years. So a lot of other things things change, and the people have to change with the ruling. It doesn't make it right.
All right, questions for the applicant or staff from board members?
I have a question for the Lions. Who uses these? How big a family do you have that you need 3 residences on the same lot?
So my husband, we bought the lot next door, so we actually own the 2 plots.
Yep.
So my mother-in-law, who comes up every June until September from Florida, she stays on the second property. We actually have 4 boys, all adults, and one of my sons has 6 grandkids. So they don't stay in them all the time, but occasionally when we have all 6 grandkids, they stay in there. Our permanent resident that me and my husband stay in is just a 2-bedroom. And, we could have the 6 grandkids sleep in the middle of the living room, but they will stay in there when we do. Otherwise, it's just for storage for our tube and our umbrella and our extra yard things that would be sitting out in the yard.
Question for.
Go ahead, Jared.
A question for staff. So, how did this situation come to light? Why is it on there?
Mr. Chair, Commissioner George, so as you can imagine, when there was started a lot of discussion about recreational vehicles, and so any of these that we're pursuing are all complaint-based. None of them are staff or county employees pursuing any of these. There's those that we received a valid written complaint. We know that there's more out there, but the position that the county has taken is that unless we receive a valid complaint or unless someone applies for a permit to do something on their property, it remains, or unless there's a sheriff's department complaint related to noise or parking, etc.
So I look at this as an opportunity to get us back to standards, existing standards. That's my position.
I have a question for the Lions. The 2 RVs there, do you have septic hooked up to those 2?
There's not any bathrooms in them.
What about water?
There's no water in them. when we bought the property 5 years ago, in there is 3 bedrooms or 3 beds, but everything else was taken out. There's no toilets, there's no sinks, there's no kitchen, nothing.
Okay.
They're just,
And then my next question is, then the septic system that the main home is hooked up to, is that sized then for like 2 bedrooms or?
sorry. I don't know like how big your septic needs to be for a certain amount of people. I know it's the size for that unit. And then next door where my mother-in-law is, we just moved that camper in and that put a brand new septic in there, and that's a 1,000-gallon tank.
But that's a separate lot.
They're still attached, and we still share back and forth. We're still a family. No
But
matter,
legally, they're a separate lot.
yeah,
Okay.
legally
All right,
they're separate
thank you.
lots. Yeah.
Any other questions, comments to staff or applicant?
Well, I'll ask the Lions or their attorney. When you bought the property, did the seller point out that what they were selling you wasn't allowed?
No, when we bought the property, the first property where the campers are, it was sold as a property with 2 bunkhouses, and that's what it says in the listing. Okay. And that the 2 bunkhouses each had 3 bedrooms in it. When we went to buy the next property, which one of the campers is over one of the properties, the reason why there was a complaint was the previous buyers before we bought wanted that camper moved off the property line. So that's where the complaint comes from, is from the realtor and the previous buyers as far as moving that camper. But those campers were listed as the property as being 2 bunkhouses with 3 bedrooms in it when we bought 5 years ago.
A question for the applicant. Was there a survey taken at that time?
When we bought our property or the other property?
Well, either one.
Okay, so when we bought the first property, we asked the realtor to do a survey. A week and a half later, we came out and there was stakes going, is it 4 feet? 4 feet from the camper. There was stakes with flags going up the property, up the driveway. When the people next door, 4 years later, were going to sell their property, they had a survey done, and they said our survey wasn't right, and that the property line was actually the 2 feet over the camper. When we talked to the realtors would not respond to why they actually never did a survey when we wanted one, and why there was stakes in the property line on the wrong space. So we never got any clarification on why the survey was never done when we bought the first property. So now we have the 2 properties with a property line that goes down the middle of one of the campers. So we're still continually trying to fix what hasn't been fixed. But when we bought that camper, the first property, those 2 campers were there, and in the listing it said with 2 additional bunkhouses.
Okay. I have just one more question for clarification. You said the second lot that you purchased is a mother-in-law, or then she brings her own RV?
Nope, that RV that's there, it's not on here. I think we have one up here.
So between the 2 properties, there's 1 residence and 3 RVs?
So there's 2 plots. One plot is the one that you're looking at, and that one is 1, 2, 1, 2 and a half. That's the first plot that we bought. It's lot 1, lot 2 and a half. Last year we bought the next side of the driveway. So if you visited the property when you came down the driveway, there's a camper, a new camper there. And then there's a brand new septic. And that's where my mother-in-law stays. So we actually own the 2 plots. So the two campers reside between the middle of the 2 plots. So it's 4 lots that we own, 2 plots.
If you would like, Bonnie, I just threw up on a map. This might help a little bit too, Michelle. So the one camper in yellow, that's the mother-in-law's. That was permitted by the county. And then the 2 campers that we're talking about tonight are right here on the other parcel. And then the manufactured home isn't depicted on here, but it's about in this location.
Okay, that's what was confusing because
Okay.
I didn't see it in the picture.
Mm-hmm.
All right.
So she
Thank you.
actually stays on the second plot that we bought. We stay on the first plot, and the 2 campers up front are right in the middle. So there's 4 lots, 2 plots.
Any other questions, comments from board members to applicants or staff? Is there anyone in the audience wishing to speak to this request? Anyone in the audience wishing to speak to the request? Anyone in the audience wishing to speak to this request? Hearing none, looking for a motion and a second to close the public hearing.
Bonnie Mossman, motion to close.
Motion from Bonnie,
George Fiedler, second.
second from George. All those in favor?
Aye.
Same side, motion carries. And so for this one, is this a divided one or based upon what we do, correct?
This is that new after the fact
Okay,
that you got from Taylor, correct?
okay, yep, got it.
Mr. Chair, I think what you're asking is, would you possibly divide the findings? So you're dealing with the accessory structures and then you're dealing with the campers, correct, Brian?
Yeah, and I don't think we have the 2 findings for that. We could divide them if you wanted to.
Okay.
I think it's probably just fine as it is, right? Is that? Yeah, that's.
We've never really discussed the other 2.
Yeah, so
the
just
sheds,
leave,
we
yeah,
haven't-
that's fine.
We haven't discussed that at all.
Okay.
so-
All right,
So
so
are
just
we
keep with,
Doing findings.
We maybe would vote to leave those and move the RVs out. Who knows? It could go one way or the other.
it's true. Just,
I'd make a suggestion that we do the findings for the 2 RVs,
Yep.
and then come back and have discussion about the buildings, and then do findings for the 2 accessory structures.
is that,
Yeah, we can make that work, I think.
okay, so for the first one, we're dealing with our 2 specific RVs, correct? That's the, okay. Very good.
Mr. Chair,
Yes,
I'd have one question for staff.
yep, go ahead.
Is the original ordinance, is that written per lot or per owner, or is there a clarification that we could get for that?
Mr. Chair, Dave, it's based on, it's per parcel or lot of record is how the statute is written. And so it's based on, it gets complicated, but it's not per owner, it's per parcel of land.
Okay, so if there's 3 parcels of land there, does that make a difference?
No, there could be 10, but there's only 2 lots of record because it's based on the lot size. And so in order to have a separate lot of record, you have to have a minimum lot size of 40,000 square feet on this lake. So there's many parcels in shoreline that were platted back in the 1940s, 50s, 60s, 50-foot lots, and then they got combined over the years into, like this example, right? There's 2 different lots, but they make up 1 parcel.
Okay.
Yep.
All right, moving to question number 1. Is the proposed use allowed in the zoning district in which the subject property is located, yes or no?
Mr. Chairman, I'm going to say no. The ordinance is clear that there's 1 RV allowed when you have a permanent residence on the lot.
Okay.
1 allowed for 30 days per year. So I'm going to say no.
All right, we've got a no from Rob. Any differing opinions on the board for number 1?
I would agree with no.
I agree with Rob, and it's not that they have extra, they're also too close to the ordinary high water mark too, besides being extra. So I agree with Rob as a no.
Okay.
I'm a no.
Okay. No. George, Dave?
I'll be no.
Okay, no for number 1. Number 2 is the variance in harmony with the general purposes intent of the official controls. Yes or no?
Mr. Chair, I'm going to say no for the same reasons we just discussed.
Okay. I know from George, any differing opinions, or is it a no for number 2? No. All right, no for number 2 as well. Number
Mr.
3.
Chair, can we do an individual roll call
Correct.
for voting?
Yep, for sure.
Thank you.
George?
No.
Dave?
No.
Bonnie?
No.
Rob?
No.
No.
Ken? Okay. That was for number 2. Yep. And number 3, is the variance request consistent with the comprehensive plan, yes or no?
Mr. Chair, George, I'm going to say no. Under the Lakeshore Living policies, it doesn't maintain the neighborhood's residential character, and it doesn't preserve sightlines.
Okay. I'll do roll call for the rest. Dave?
Did you say Dave?
Yep.
Oh. I would agree with that. No.
So no. Bonnie?
I would say no for Lakeshore Living goals 1 and 8.
Okay. Rob?
No.
And then Ken?
No.
No for number 3. Number 4, is the property owner proposing to use the property in a reasonable manner not permitted by an official control? Yes or no?
Mr. Chairman, I'm going to again say no because there's 5 different things that we have to address in order to get them over that hurdle. So I'm going to say that's not reasonable.
Okay. George?
No.
Dave?
No.
Bonnie?
No.
Ken?
No.
No for number 4. Number 5, is the plight of the landowner due to circumstances unique to the property not created by the landowner? Yes or no?
I would say it's a little bit unique to the property because there's different parcels and they've been there for a long time and they were sold that way. And at the time they were sold, the county never brought it up that they were not legal.
Okay. It's,
so it's a little bit unique.
Sure.
Unique.
Yes from Dave. George?
No.
Bonnie?
No.
Rob?
No.
Ken?
I have to agree with Dave. It's kind of a yes deal that it wasn't, they weren't completely at fault, but
Okay. So yes from Ken, but a majority vote is no for 5. Number 6, will the variance maintain the essential character of the locality? Yes or no?
I don't believe that it's going to change the character of the locality because they've been there for an extended period of time already.
Okay, so a yes from Bonnie. George?
No.
Dave?
No.
Rob? Yes. And Ken?
yes.
Okay, so that's a yes for number You're a yes, right?
Yeah.
Yep, yes for number 6.
6.
Okay. And number 7, the need for the variance involves more than economic considerations, yes or no?
Bonnie Mossman, I don't believe that economics were a factor
Okay.
in this request.
George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number 7. So for the RV part of this, with not every category being answered as a yes, we need to look for a denial of this part of the request. And then we'd have discussion, I think, of the building piece.
Mr. Chair, I'll move to deny the request for the RVs.
Motion from George to deny the request. Can I get a second?
Mr. Chairman, Rob Schweigel, I'll second it.
Second from Rob for denial of the request. The remaining votes, Dave,
Yes.
Bonnie,
Yes.
and then Ken.
Yes.
All right, motion for the RV section of this is denied, and now wanted having a discussion on the building piece of that, correct? Okay. So what are some of the thoughts here on this piece?
I just have a question for staff. I just want to make sure I'm thinking of this clearly, is that the issue is the 10 feet from the residential dwelling, not necessarily the number of accessory structures or the square footage? Is that correct?
That's correct.
All right,
Bonnie.
thank you. If I could ask the applicant to specify if there's a particular reason why they wouldn't want to move those, they look very movable, move them, 10 feet from the residence?
What about them? So you want us to move our sheds?
Well, are they on a foundation, or are they sitting there that they'd be movable?
I guess they could be movable. I didn't know there was any issues with the sheds. This is the first I've heard about this.
Okay, well, as part of the request is to leave the sheds there.
You have to leave as constructed the residential accessory structures. That's what the sheds would be, the residential accessory structures. So that is part of the request here.
From Stearns, do you have it?
That's the variance request. Yep.
I don't have my glasses. So the brown.
The deck is from the building or the deck?
Mr. Chairman, I have a question for staff.
Yeah, go ahead. Yeah, Rob has a question.
I have a question for you. It said the accessory structures that are less than 10 feet from a residential dwelling unit. So if they were 11 feet, they'd be okay? Is 10 feet the setback from a
Yes.
residential structure?
Yes, Mr. Chair, Member Schwagel, 10 feet is the setback from the primary dwelling. That's a fire code item that we address with that setback. One thing to note, one of these structures would be allowed to be moved closer to the ordinary high and used as the water-oriented accessory structure, as long as it is no greater than 150 square feet in area, not on a foundation, and less than 10 feet in height. We wouldn't even need a permit for it. We could only have one of these accessory structures moved closer to the lake, as they're only allowed one water-oriented accessory structure. The other structure would have to meet that 100-foot setback and 10 feet from the primary dwelling. They're both under that 150 square feet, so we wouldn't need a construction site permit for them unless they chose to put a foundation under that water-oriented accessory structure. But if it's not on a foundation, we don't even need a permit for it.
There's not a foundation under them. They're plastic. They're plastic.
Is it from the house or the deck?
It has to be from anything that's attached to, so that because of the awning, that's where you have to get 10 feet from that, because the fire could jump from that structure to the awning to the house. So we have to keep that 10 feet from anything, whether it's an attached deck or awning or a covered porch or whatever it might be.
I have a question for the Lions. Were these there when you bought the property?
Yes. Everything was there. You know?
So when the place went up for sale, how come like none of these things were looked at before people listed it or anything? Like the campers, the sheds, you know, you have buyers coming in buying places, and then all of a sudden it's turned around and it can't be like that. So wouldn't this have been looked at all before something goes up for sale?
Well, that would be the previous owner and the realtor's responsibility. You know, the county doesn't have anything involved to do with sale of the property.
Angie?
Right. It's basically what Bonnie said. I'm sure your attorney can weigh in that Minnesota's a buyer beware state. So unlike the sewage treatment rules, when property transfers, it has to come into compliance. There is no such thing like that for zoning. So only unless somebody calls us, the listing realtor, the buyer's realtor, or the buyer calls and says, here's what I'm looking at buying, is it in compliance? My understanding is that years ago there was something added to the purchase agreement about, do you have all proper county permits? Again, we don't get involved in the real estate transactions, and so we would have no way of flagging this for a potential issue.
No, I have a question for staff. If they move, like the brown one, far enough away from the residential structure, and they take the other one and put it on the other lot? Not the other lot, but the other parcel that they own next door. You own the next parcel also. I don't think there's any, you don't have any accessory structures on that one. You just have the...
There is one over there.
There was one.
Okay.
But I think the issue here, you know, they can have both of these because they can have a water-orientated one plus another structure. So they can have the two structures. It's just the 10 feet from the house. And I guess, and as long as the county wouldn't be held liable for any, you know, if there was a fire problem or something for permitting or for giving a variance for it, you know, I don't think to me, it's not a big issue.
For me, it's an issue. This is an opportunity, again, for us to comply with the standards and get back to the standards. It's easily done. They're movable.
Any other thoughts from board members or?
Well, we'd have to do findings and.
Yeah. All right, so we'll do our findings of facts on these two residential accessory structures now at this point, since we've had some discussion on it. I think that's wrapped up for the discussion parts of that, right? Everybody to their satisfaction for that part?
Yeah.
All right, so let's go to number one for these residential accessory structures. The proposed use is allowed in the zoning units in zoning districts in which the subject property is located, yes or no?
Accessory structures, and the number and size of these current structures would be acceptable.
All right, I guess from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number one. Number two, the variance will be in harmony with the general purposes and intent of the official controls, yes or no?
Mr. Chair, George, no, it's not. They're not in compliance with what the ordinance states.
Okay. Dave?
I would say no.
Bonnie?
I have to say no.
Rob?
No.
Ken?
No.
No for number two. Number three, the variance will be consistent with the comprehensive plan, yes or no?
Mr. Chair, George, I would say it does. It does. It is consistent with the plan under Lakeshore Living policies.
Okay. Yes from George. Dave?
Yes.
Bonnie?
Yes.
Rob? Ken?
Yes.
Yes for number three. Number four, the property owner proposes to use the property in a reasonable manner, yes or no?
Mr. Chair, George, I'm going to say no because they're not abiding by the ordinance.
Okay. No from George. Dave?
I would say no.
Bonnie?
No.
Rob?
No.
Ken?
I would say yes, because they're there, and if they move them to the proper places, they're allowed to have them. They just aren't allowed to have them exactly where they are.
Okay, yes from Ken, majority no for number four. Number five, the plight of the landowner is due to circumstances unique to the property not created by the landowner, yes or no?
I would have to say, Mr. Chair, this is unique to the property. The property owners, the new owners came in not knowing all these rules. They just left everything as is. And so they did not create this. They just were kind of handed this and didn't know that these things were against the rules, which is something we've been fighting in the county for a long time. So,
George?
No.
Dave?
Yes.
Bonnie?
Yes.
Rob?
No.
All right, majority yes for number five. Number six, the variance, if granted, maintains the essential character of the locality, yes or no?
I would say yes, because I don't think it's really going to change anything. It's the way they've always been.
Okay, yes from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
yes.
Yes for number six. Number seven, the need for the variance involves more than economic considerations, yes or no?
Mr. Chair, George, I don't think economics has a role in this part.
Okay. That's from George. Dave,
Yes.
Bonnie,
Yes.
Rob,
Yes.
and Ken.
Yes.
Yes for number 7. Since there are several sections where there are no answers, we need to look for a motion to deny the request for the residential accessory structures.
Mr. Chair, George, I'll move to deny.
Motion from George. I need a second.
Mr. Chairman, Rob Schweigel, I'll second it.
Okay. Rob. Remaining votes, Dave.
Yes.
Dave's a yes. Bonnie
Yes.
and Ken.
Now we vote yes, we're voting with them or against them?
Would be for the denial.
For the denial.
No.
Okay, no. Right, so therefore, a majority voting for the denial of the place to leave as constructed the 2 residential accessory structures. The motion is denied, and if you have any questions, please do talk to staff during regular business hours.
But again, I think we need to point out in the meeting minutes that it's, even though it's denied, they can fix it easily just by maintaining the 10 feet.
Angie, do we just continue with the along in place number 1 at the end, or?
Yes, Mr. Chair, I can give you all an update. So the applicant understood that the solar company was going to be attending for him, and he is not able to, he could be here if needed. He has a broken knee, and it sounded like a lot going on. So what I told him we would do is when we got to the second to the end, is I would text him and then let him know we'll call him, and we'll just put him on my speakerphone and handle it that way. He really doesn't want to have it continued.
Sure, okay.
Okay.
Thank you for letting me
Thank
know. Item number 4, a request from Mark Hoffarth and Susan M. Hoffarth, Joint Revocable Trust, Clearwater, Minnesota, from Section 10.211A of Stearns County Land Use and Zoning Ordinance 439 to construct a residential accessory structure less than 200 feet from the ordinary high water level, and to leave as constructed 2 residential accessory structures that are in the shore impact zone of Bunt Lake, classified as natural environment, affected property lot 014, block 001 of Woods Edge Second Addition, Linden Township, and the property address is 20445 Elmwood Road in Clearwater, Minnesota. And if those applicants could please come forward. And if I can get your names and addresses for the public record, please.
My name is Mark Hoffarth. Address is 20445 Elmwood Road, Clearwater, Minnesota.
Susan Hoffarth, 20445 Elmwood Road, Clearwater, Minnesota.
Thank you very much. And then we'll be back to you after our staff report. To report.
Thank you, Mr. Chair. Let's start with asking if any of the members were able to visit the site by a verbal roll call.
Okay, George, were you able to make it?
No.
Dave?
Yes.
I was able to make it. Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
All right, you have your votes for that.
All right, thank you. And then any communications with the applicant or others regarding this request from any of the board members?
I had a communication with the applicant showing me the location and 2 structures that were in
Mark also about the location and the plans for it.
Thank you, Mr. Gamrot and Mr. Schwegel. We'll move to the report. The applicant is requesting a variance from section 10.2.11A of Stearns County Land Use and Zoning Ordinance number 439 to construct a 1,429.75 square foot residential accessory structure 173.5 feet from the ordinary high water level, and to leave as constructed 2 residential accessory structures that are in the shore impact zone of Bunt Lake, classified as natural environment. Said ordinance requires accessory structures to be placed 200 feet from the ordinary high and allows for 1 residential accessory structure no greater than 150 square feet in area and not to exceed 10 feet in height to be within the shore impact zone, but at least 25 feet from the ordinary high water level. The applicant owns Lot 14, Block 1 of Woods Edge Second Edition. Woods Edge Second Edition is in Linden Township and was platted in 1979. The property is in the Shoreland Overlay District of Bunt Lake, which is classified as natural environment. The tract is approximately 2.94 acres according to the certificate of survey submitted by the applicant and is in the R1 zoning district. The applicant has owned the property since 1984 and received a permit in 1985 to construct the existing dwelling with attached garage. The subsurface sewage treatment system that services the dwelling was installed in 1985, repaired in 2017, and certified compliant in 2022 by an inspector licensed with the state of Minnesota. An alternative to the request would be to modify the request to build a structure that meets all required setbacks. Linden Township, the Minnesota Department of Natural Resources, and property owners within 500 feet have been notified of this request. Alternatives and recommendations. Grant or deny the variance as requested based on the findings of fact. An alternative, again, would be to build a structure that meets all the required setbacks. And if granted, the condition that the applicant maintains the natural conditions of the area between the proposed structure and the ordinary high water level of Bunt Lake as a buffer of any impacts from the proposed structure. We have not received any correspondence here at the county regarding this request. That is all I have, Mr. Chair.
All right, and applicants to your request.
I'm requesting to build an accessory structure to be used as a workshop and storage for my RV unit. That would be 173 and a half feet from normal high water mark, which was surveyed in 2017. I also have two accessory structures that I refer to as wood cribs for storing firewood. And they're just to the upper left of that pond area, straight north of the proposed structure. Those are 8 by 8 foot structures made with landscape timbers, and then 2 by 4s for each corner and 2 by 4s to support a tarp for keeping my firewood dry. This is what they're referring to. I'm referring to. And that would be it.
Okay. Board members, questions for the applicant or staff?
Is there, I'm sorry, is there also a solar part to this?
No.
That's,
The beginning. Yep.
A different one got combined with
Okay, sorry, my
we
mistake.
had a new one tonight.
Yeah.
Yeah, there was a bit of a clerical error on that in the beginning, and we're working through it. So it'll be ironed out by the time we're done.
Mr. Chairman, I have a question for staff. You said one of the solutions would be to move it to meet the setbacks. Is that possible? I mean, you got the road setback and the ordinary high water and the 200-foot setback.
Yeah. Mr. Chair, Member Schwegel, the alternative was to construct something that met the setbacks. They think they've got a sliver of ground that would meet the setbacks, so it's just a general alternative. I don't know the viability. You'd have to look at what's available.
I'm going to assume that the hash line that goes through the proposed structure is the high water mark.
That's the 200-foot setback. Yep.
Right.
Yep.
And then
that's correct.
Dash line below that
Is the 30-foot setback from the road right away. Yeah. Yeah.
Well, yeah. Triangular shaped building or something.
And I had it surveyed to move the proposed building up tight to the road setback. So that's what I'm left with.
I have a question for staff. Now, the shed that's on this picture over there to the left of the house, is that like the water orientated? Is that what that one's designated as?
Mr. Chair, Member Mossman, that shed meets the 200-foot setback, so it's just an accessory structure.
Oh, okay, so that's
That
okay.
doesn't, yeah, that
And
doesn't.
then our definition of accessory structures, if it has a tarp for a roof? Is it really a structure?
Technically, yes. Technically, yes. It is a structure. So it serves the purpose as a structure regardless of, we don't specify in materials. In the definition of a structure, it's just because of how it functions, it's a structure.
So if he stacked the wood there and took the tarp off, then it wouldn't be a structure.
He could stack the wood and put the tarp on top of the wood without the walls, and it wouldn't be a structure.
Okay.
It's awfully vague.
Yeah, so.
Oofta.
So what if you had walls without a roof and just laid the tarp on top?
If you want to debate the definitions, we can certainly go through them, but this is longstanding. It goes back to the definition of structure, and then you have to look at the definition of building, because the definition of structure references building. So it's up to you. If you want to go through that, I can read them.
So we're just hoping that property owners listening to all of these vague things, and we can vote against it, and all he has to do is take the 2x4s down and lay the tarp on top, and
He's okay.
it's all good.
Allowed one.
Oh, he is allowed one.
It's allowed one. He has.
What if they were to connect, the two that are there are connected? They'd be one.
It would be 128 square feet, which is still under the 150-foot max.
So nail up a couple 2x4s to connect them.
Question for the applicant. Is this your primary residence?
Yes.
Okay.
Any more comments or questions for the applicants or staff at this time? Anybody from the audience wishing to speak to this? Anyone from the audience wishing to speak to this? And anyone from the audience wishing to speak to this? There is nobody from the audience wishing to speak to this, so I would need a motion and a second to close the public hearing.
I'll make a motion to close the public hearing.
All right, motion from Bonnie. Can I get a second?
I'll second it.
Second from George. Dave?
Yes.
Rob? And Ken?
Yes.
All right, we have closed the public hearing. Motion there passes. And is that one we need to divide into two, right?
Mr. Chair, we have it as two findings of fact. I don't think we can combine them into one, can we, Angie?
One is after the fact and one is not. So, right, you'd have to do two separate findings, no matter what.
All right, so starting first with then to construct the 1.42975 square feet residential accessory structure. We'll start with that one first then. Number one, the proposed use is allowed in the zoning districts in which the subject property is located, yes or no?
Bonnie Mossman, yes, accessory structures are allowed in this area.
Okay, yes from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
Ken?
Yes.
Yes for number one. The variance will be in harmony with the general purposes and intents of the official controls, yes or no?
Mr. Chair, George, I'm going to say no because it doesn't comply with the standards.
No from George. Dave?
No, we're just talking the accessory building.
To construct.
To construct the new.
Yes.
Building.
The new building, yep.
I would say he doesn't, he maybe has space that he could put it, that would be far enough away, but it would seem not, I would say, I would have to say that, no.
Okay. No from Dave. Bonnie?
I'm going to say yes, because
should
I
say
think
yes.
he is, he placed it as far back as he possibly could. So I'm going to say yes, because whatever he did, he was going to need a variance, whether it was from the road or the ordinary high water. So
Mr.
I'm going
Chair,
to say yes.
I would change my vote to yes.
Okay. Dave changes his vote to yes. Rob?
Yes.
And then Ken?
Yes.
Yes for number 2 from the group. Number 3, the variance will be consistent with the comprehensive plan. Yes or no?
Mr. Chair, I'm going to say yes, accessory buildings are allowed.
All right. Number 3 is a yes from George. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number 3. Number 4, the property owner proposes to use the property in a reasonable manner. Yes or no?
Mr. Chair, George, I'd say yes. Having a workshop accessory building is a reasonable use.
Okay. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Ken?
Yes.
All right. Yes for number 4. Number 5, the plight of the landowner is due to circumstances unique to the property not created by the landowner.
Mr. Chairman, yes, it is unique to the property. He can't meet both setbacks.
Yes from Rob. George?
Yes.
Dave?
Yes.
Bonnie?
Yes.
And Ken?
Yes.
Yes for number 5. Number 6, the variance, if granted, maintains the essential character of the locality. Yes or no?
I believe yes. After visiting that area, I believe that this shed won't look out of character from the rest of the houses and buildings that are there.
Okay. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number 6. Number 7, the need for the variance involves more than economic considerations. Yes or no?
Mr. Chairman, I don't think economics played a role in it at all.
Okay. Yes from Rob. George?
Yes.
Dave?
Yes.
Bonnie?
Yes.
Yes.
Yes for number 7. So we've had all of these 7 questions answered in the affirmative. So we'd be looking for a motion to approve this variance request.
Cameron, I would make a motion to approve the variances requested.
Motion to approve from Dave. Can I get a second?
I'll second.
Okay. Second from Bonnie. All right. George?
Yes.
Rob?
Yes.
And Ken?
Yes.
All right. Those being answered in the affirmative, the section for the construction piece is now approved. And then now moving to leave the constructed pieces of the 2 residential accessory structures. We'd be moving on to those questions now for finding of fact. Number 1, is the proposed use allowed in the zoning district in which the subject property is located? Yes or no?
Yes, accessory structures are approved in this area.
All right. A yes from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
Ken?
Yes.
All right. Yes for number 1. Number 2, is the variance in harmony with the general purposes and intent of the official controls? Yes or no?
Mr. Chair, I'm going to say no. It doesn't abide by the 200-foot setback.
Okay. A no from George. Dave?
My common sense says yes.
Okay. Bonnie?
Yes.
Rob? Yes. Ken?
Yes.
Yes for number 2. Number 3, is the variance request consistent with the comprehensive plan, yes or no?
Mr. Chair, I'm going to say yes, but it is not, it doesn't abide by the ordinance, but it's, I believe it's consistent with the comprehensive plan.
Okay. Yes from George. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Ken?
Yes.
Yes for number 3. Number 4, is the property owner proposing to use the property in a reasonable manner not permitted by an official control? Yes or no?
I guess he is going to use them in a reasonable manner. These are for holding firewood. What more reasonable use would you have for them? So I say yes.
All right, George?
Yes.
Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Yes for number 4. Number 5, is applied to the landowner due to circumstances unique to the property not created by the landowner? Yes or no?
Mr. Chair, I'm going to say no.
Okay.
I don't know if he's the one that put those there, but he made a decision to put them there. They're out of compliance.
Okay, Dave?
I would say yes.
Bonnie?
I'm going to say yes.
Rob?
Yes.
Yes.
Yes for number 5. Number 6, will the variance maintain the essential character of the locality? Yes or no?
I would say yes. The sheds are located on the edge of a wooded area and they're housing wood. So I think it would be yes.
Okay. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Number 7, the need for the variance involves more than economic considerations? Yes or no?
Mr. Chair, I don't think there was economic situations considered in this here when there are a couple of planks on the ground with some 2x4s on the corners to hold the tarp up. So that wasn't a great financial thing. So I don't think it economic considerations.
George?
Yes.
Bonnie?
Yes.
Rob? All right, so that's a yes for number 7. So all questions being answered in the affirmative, I'd look for an approval for this variance request to leave as constructed the 2 residential accessory structures that are in the shore impact zone of Bunt Lake, classified as natural environment.
I would make a motion to approve the.
Motion from Dave, second.
I will second them.
All right, second from Ken. The remaining votes, George.
Yes.
Yes from George. Bonnie
Yes.
and Rob. With that, all those answers being the affirmative, that variance request also passes. So if you have any questions for staff, please visit with them during regular business hours. Thank you.
Thank you very much.
Thank you.
All right, moving on.
Mr. Chair, would it be a good time to take a break?
Yeah, should we take, what, a 5-10 minutes? What do you think, Angie? Because you need to contact the person, right?
We can take him at the end, and you can take everyone else you have here first. We'll put the one on,
Where they don't have to wait.
right.
Okay, so did you want to break then, or?
Yeah.
Okay, 5 minutes, okay?
5, yeah.
5-minute break. The board is in recess for 5 minutes. recess at 8:02 p.m. here, and then we will now hear item number 5, which is a request from Stephen and Pamela Klopaki, Freeport, Minnesota, from sections 10.211A of Stearns County Land Use and Zoning Ordinance 439 and 6.5 of Stearns County Subsurface Sewage Treatment System Ordinance 422 to construct a new residential dwelling less than 100 feet from the ordinary high water level ahead of a building line and in the shore impact zone of Big Birch Lake, classified as recreational development on an existing holding tank. Affected properties lots 11, 12 of Sunset Beach Edition, Section 32, Millwood Township, and that property address is 30244 Shady Lane in Melrose, Minnesota. And if those applicants could please come forward. And then, Dave, you wanted to abstain from that?
Yeah, they're my brother-in-law and sister-in-law, so.
So that could affect it negatively as well as positively, right?
I don't know.
All right. And
I don't beer. He can sip.
And if we can get your names and addresses for the
Steve
public record,
Klopaki, 31602 County Road 11.
And Pam Klopaki, 31602 County Road 11, Freeport.
Perfect. And then staff to your report.
Thank you, Mr. Chair. Just to verify then, Jacob, you will be voting on this one?
Correct. Yep. Since there's, yep.
All right.
And then for who was able to visit, George, did you visit?
No.
Dave?
Yes.
I did. Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
All right, there you go.
Thank you. Mr. Chair, were there any communications, correspondence with the applicant or others, if you could, by verbal?
Yes, I spoke with the applicant and just had a general description of the project and talked to her about where the building lines were between the two houses.
Thank you, Member Mossman.
Remember to put her name down, not my name. We went through this. You weren't here last month.
Just don't put Member
put a K or a B down because
Ken, I don't keep the
I
don't keep the minutes.
But I didn't speak to them.
Okay. Yeah. Thank you for the clarification. We'll have that in the minutes now, Ken. Okay, so the request is the applicants are requesting a variance from sections 10.2.11A of Stearns County Land Use and Zoning Ordinance number 439 and 6.5 of Stearns County SSTS Ordinance 422 to construct a new 2,300 square foot residential dwelling 26 feet from the ordinary high water level ahead of the building line and in the shore impact zone of Big Birch Lake, classified as recreational development on an existing holding tank. Said ordinance requires a new residential dwelling be placed 100 feet from the ordinary high, landward of the established building line of a lake classified as recreational development and does not allow the use of holding tanks for new residential dwellings. The applicants currently own lots 11 and 12 of Sunset Beach Edition in Millwood Township on Big Birch Lake. Sunset Beach Edition was platted in 1949. The property is in the Shoreland Overlay District of Big Birch Lake, which is classified as recreational development. Big Birch is on the list of impaired waters for nutrients and mercury in fish. The property is in the R1 zoning district, and the tract contains 11,697 square feet in lot area that is above the ordinary high water level per the survey provided by the applicant. The applicants purchased the property in 1999. There is an existing 1,028 square foot residential dwelling that was constructed in 1971 per the Stearns County assessor records prior to official controls. There is an existing 620 square foot deck on the lake side of the dwelling that was constructed in 1971 with the dwelling and replaced in 2008 with a permit that is being proposed to be removed. There's a 176 square foot gazebo that was constructed in 2012 without a permit that is 15 feet from the ordinary high of Big Birch Lake and 7 feet from the side property line that is also proposed to be removed. The existing holding tank that services the dwelling was permitted and installed in 1999. A compliance inspection was completed on the system by a licensed inspector in June of 2022. The tank was determined to be compliant. The current impervious lot coverage of the property is 33.5% per the survey provided. The proposed impervious lot coverage when the project is completed will be 25%. An alternative to the request would be to replace the existing and I'm going to add a correction here because I did miss a number on this report, but replace the existing 1,028 square foot dwelling that was constructed prior to the official controls without any expansion. Millwood Township, Big Birch Lake Association, Sauk River Watershed District, the Minnesota Department of Natural Resources, and property owners within 500 feet have been notified of this request. And we have some alternatives. Again, would be to, pardon me, I'm jumping around here. Grant or deny the variance as requested based on the findings of fact, or replace the existing residential dwelling that was constructed prior to the official controls without any expansion. If denied, complete the after-the-fact findings for the existing gazebo constructed in 2012. If granted, require that a pumper's agreement be submitted by the applicant for the existing holding tank because we don't have one on file. We didn't require that when the existing tank was installed. And then we did get mitigation suggestions from Stearns County Environmental Services, or Stearns County Soil and Water Conservation District that was provided with the application. And the county would suggest that mitigation as well if granted.
Any correspondence?
No correspondence has been received on this request.
Okay, thank you. Applicants, to your request.
Well, as we're trying to retire from dairy farming, my two sons want to take it over. And we've had the cabin since '98, and we want to, and it's a cabin, it's not a home, and we want to remove that and build our dream home kind of out there. Anything else? I know there's the tank, and nobody else along there can put a drain field in. There's no option for us to have a drain field. All of the water running off of the proposed home is going to go in to the south towards the swamp, which is Pam likes her hosta and things like that. So, I mean, probably not going to have any lawn except for in the front facing the lake.
Okay, any questions or comments from the board for the staff or applicants?
I have a question for staff. It looks like their completed project will be 25% or under, but just for clarification, you know, when I added together the current house, the deck, and the gazebo, I came up with like 13%. And on here it says 33.5%. You know, they don't have that much concrete or anything around to make. I'm just wondering how you came up with they came up with 33%.
Mr. Chair, Member Mossman, I'm using the numbers that were provided by the surveyor, and they count all the hardscape on the property. I removed some of the hardscape that was counted because it's not something that we typically calculate, like he has in there the covers on the manhole covers on the septic. We don't usually calculate those. He's got some of the rock landscaping edging that he counted, and that it's a lot of work to go through and calculate that out, but I went through and counted all the things that we would typically count, and it was most of what you may have been missing could have been the driveway, the gravel driveway that we do have to count.
Still be there? And if the house is getting bigger, I just didn't see how the house could be larger, you know, over three times larger, and the impervious surface dropped, even though you're taking the gazebo and the deck out. I don't know, the numbers just didn't work for me.
And I can speak to that as well. You'll see in the survey that was provided by the surveyor on behalf of the applicants that there are 4 tire track areas for entering and exiting the proposed garage, and that was in an effort to stay below that 25% or stay at that 25% or lower. So the request is to remove all of that gravel and replace it with those 4 tire tracks. I believe they're about 2 feet wide is what the surveyor put on there. And then the length from the right-of-way to the, I believe it was a 4-foot apron in front of the garage, 3 or 4 foot, somewhere in there, so.
Okay, thank you. Numbers just didn't work for me.
Any other questions, comments? Go ahead.
I have one more question. When it talks about the building line, I'm trying to see from the house on the northeast, are they drawing that building line? And I probably asked this question multiple times, but from their deck or from the corner of the house?
Mr. Chair, Member Mossman, in this case, the dwellings east and west of the proposed project were within the shore impact zone. So to calculate a building line, we have to come back to that shore impact zone as it intersects with the property line, and that's a 50-foot shore impact zone setback. So they get the max allowed building line without being within that shore impact zone.
Negates the building.
Yeah, pretty much.
Takes precedence over it. Okay.
Yep, the shore impact zone is
All
more
right.
more restrictive than building line and takes priority.
Thank you.
Anyone else?
I have a question for the Klopakis. What makes you need to go that much closer to the lake?
We're really not going any closer.
No, we're not going closer.
No, because the front of your existing cabin is, I mean, that's where we would like to have our home, front of the home. We're really not going any closer. Well, maybe, I shouldn't say that. Right there, if you can point it out to them, that gazebo, we're taking it out.
It's only 4 feet difference.
My understanding
from
looking.
I just got the impression that it was a lot more than.
I guess it turned out because we want to line it up with the property lines.
Right now, the current structure is 30 feet according to the survey. That's the green circle to the left, and the proposal is 26 feet.
Any other questions, comments from the board? If not, anyone in the audience wishing to speak to this item? Anyone in the audience wishing to speak to the item? And anyone in the audience wishing to speak to this item? Nobody in the audience wishing to speak to the item. Looking for a motion to close the public hearing.
Mr. Chair, I'll move to close the public hearing.
A motion from George, second.
I'll second. Bonnie Mossman?
Second from Bonnie. Okay, I vote yes to close the public hearing. Rob?
Yes.
And Ken?
Yes.
All right, public hearing has now been closed. Now moving to our questions for the new construction. The proposed use is allowed in the zoning districts in which the subject property is located, yes or no?
Bonnie Mossman, the property is in an R1 and houses are allowed in R1.
All right, a yes from Bonnie. George?
Yes.
I'm a yes. Rob?
Yes.
And Ken?
Yes.
Okay, yes for number 1. Number 2, the variance will be in harmony with the general purposes and intent of the official controls, yes or no?
Mr. Chair, I'm going to say no because I don't see the need to further expand a non-compliance with a bigger structure.
Okay.
Mr. Chairman, could I add to that?
Yeah.
Stearns County Ordinance 10.30 says that in no case any principal structure shall be permitted closer than the following distance on residential, recreational developmental lakes no closer than 50 feet.
Okay, so you're a no then, right? Okay. Bonnie?
I'm going to say yes because of the fact that they are not going any further ahead, or not relatively, not any further ahead than the current house. And moving the house back looks like they would be into their drain field and septic system setbacks to try to move it back toward the road. So I'm going to say yes.
Okay, Ken?
I'm saying yes for pretty much the same reasons. They're not getting any closer than the present house is.
Okay, and I'm a yes, so that's a yes for number 2. Number 3, the variance will be consistent with the comprehensive plan, yes or no?
And I am going to say yes for this one. Quoting Lakeshore Living Policies 6 and 8. And 6 talks about mitigation requirements. And I think we hadn't discussed that yet, but we can discuss that in the motion. You know, if we look at doing some type of mitigation, I think I would, be able to say yes for that one then.
Mr. Chair, just to clarify, the Soil and Water Conservation District comments said that they would recommend that you continue this before considering approval for a stormwater management plan. So I don't know if that weighs into your discussion or decision, but my understanding is Brian shared that with the applicant a couple weeks ago. So it says that with the constraints on the parcel, the Board of Adjustment could direct the applicant to determine feasibility of this option before considering approval. Basically, the parcel is so small that we can't even come up with any mitigation like we typically can.
Mr. Chair, I'm wondering if we can, we probably don't want to do we want to complete findings before we would
Probably
have
not.
it? Probably not.
I wouldn't think so. So it'd probably be, one way or the other, so.
Yeah, because it could change people's thinking of the other questions.
The applicant.
Mr. Chairman, can I say something?
Yes, please.
The roof lines are changing to direct the water away from the lake. The existing elevations is all going toward the south through the swamp, and that's probably the most perfect situation for any water is to go into the swamp to clean the water. And it's just my I wish we could put a drain field in, but we can't. We don't have the land.
Should we continue on then, or what's the thoughts of the board?
I'd say let's continue on.
Okay. The general consensus to continue on with the findings. Okay, so you had a yes for number 3, right, Bonnie?
I think I'll remain that.
Okay, George?
I'm a no.
I'm a yes. Rob?
No.
And Ken?
Yes.
That's a yes for number 3. Number 4, the property owner proposes to use the property in reasonable manner, yes or no?
Mr. Chair, yes, they propose to use it in a reasonable manner, but they're exacerbating the existing noncompliance.
Okay. Yes for George. I'm a yes. Bonnie?
Yes.
Rob?
No.
And then Ken?
I guess yes.
Okay. Yes for number 4. Number 5, the plight of the landowner is due to circumstances unique to the property not created by the landowner, yes or no?
Mr. Chair, I'm going to say no. There's an existing structure. They're proposing to make it bigger. Again, I believe they're increasing the issue of non-standard distances.
Okay.
Mr. Chair, Deb is asking that you all please speak a little bit more close to the microphone.
Okay.
Thank you.
Bonnie?
Oh, you're waiting on me.
5, the plight of landowner.
Plate. I'm going to have to say no because of it's the landowner who's choosing the size
Okay.
of the home to put there.
Sure. Rob?
No.
Ken?
No, it's created by the landowner, so whichever way that goes, yes.
And so all of us voting no on number 5. So no. Number 6, the variance if granted maintains the essential character of the locality, yes or no?
Mr. Chair, I'll say yes on that. They're building a house. There's other houses in the area.
Okay. Yes from George. I'm a yes. Bonnie?
I'll say yes, even though what they're proposing is larger, it appears larger than the neighboring properties, but I will say yes.
Okay, Rob?
No.
And then Ken?
Yes.
Okay. Yes for number 6. Number 7, the need for the variance involves more than economic considerations, yes or no?
I think yes, it does. Economics really weren't a factor in this.
Okay, yes from Bonnie. George?
Yes.
I'm a yes. Rob?
Yes.
Ken?
Yes.
Yes for number 7. So since one of the sections was answered as a no, we do have to look for a motion of denial for this new construction, or proposed new construction.
Mr. Chair, I'll make a motion to deny the request.
Motion from George, second.
Mr. Chairman, Rob Schweigel, I'll second it.
Second from Rob. I'm a yes. Bonnie?
Yes.
And then Ken?
Yes.
Yes. All right, that denial has been voted by the board, and then so now we move to the gazebo, correct? Okay. So that part, this is to retain the 176-foot gazebo there, so that we're moving to the findings of the fact for that. Number one is the proposed use allowed in the zoning district in which the subject property is located, yes or no?
Bonnie Mossman, it would be an accessory structure, and they are allowed.
Okay, yes from Bonnie. George?
I'm a no. It's not in compliance.
Okay, I'm a yes. Rob?
No, it's not allowed where it's at.
Ken?
No.
Okay, so that's a no for number one. Number two is the variance in harmony with the general purposes and intents of the official controls, yes or no?
Mr. Chair, I'm going to say no. It doesn't abide by the standards.
Okay, a no from George. I'm a no. Bonnie?
No.
Rob?
No.
Ken?
No.
No for number two. Number three is the variance request consistent with comprehensive plan, yes or no?
Mr. Chair, I'm going to say no, because it doesn't abide by the standards of the ordinance.
Okay, I'm a no. Bonnie?
No.
Rob?
No.
Ken?
No.
No for number three. Number four is the property owner proposing to use the property in a reasonable manner not permitted by an official control.
I would say yes, a gazebo is a reasonable use.
Okay, yes from Bonnie. George?
Yes.
I'm a yes. Rob?
Yes.
Ken?
Yes.
Yes for number four. Number five is the plight of the landowner due to circumstances unique to the property not created by the landowner, yes or no?
Mr. Chair, I'm going to say no. The placement of the gazebo is not a feature of the property itself.
Okay. No from George. I'm a no. Bonnie?
And I would say no and add the reasoning that it was placed there by the current landowner without a permit.
Okay. Rob?
No.
Ken?
No.
No for number five. Number six, will the variance maintain the essential character of the locality, yes or no?
I'm going to say that it doesn't change. I would say yes, so it doesn't change the character. The structure actually matches the house and style of houses you'd see
Okay.
along a lake.
Yes from Bonnie. George?
Yes.
I'm a yes. Rob?
Yes.
And Ken?
Yes.
Yes for number 6. And number 7, the need for the variance involves more than economic considerations. Yes or no? I'll say yes. Economics weren't really considered, at least, or mentioned in this factor. George?
Yeah, yes.
Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
All right, since some of these were not answered in the affirmative, we do need a motion to deny this part of the variance request to retain the gazebo. So motion, and then a second.
Mr. Chairman, I'll make a motion to deny the variance.
Okay, motion from Rob, second.
I'll second.
Second from George. I vote yes. Bonnie?
Yes.
Rob, Ken?
Yes.
All right, this variance request has been denied, and if you have any questions for staff, please contact them during business hours. And then item number 6. To consider the request from Philip Sowden, Steve Anderson, Maple Grove, Minnesota, from Section 6.21P, Table M of Stearns County Subsurface Sewage Treatment System Ordinance 422 to leave as installed a subsurface sewage treatment soil treatment area less than 20 feet from a residential structure and less than 100 feet from the ordinary high water level of a lake classified as recreational development. Affected property is Lot 004, Block 002 of Baywood Addition, Section 34, Sauk Center Township. Property address is 40047 Sauk Hill Circle, Sauk Center, Minnesota. And if that applicant could please come forward. And then can I get your name and address for the public record, please?
My name's Steve Anderson. My address is 38210 County Road 10, Albany, Minnesota.
Thank you very much. And staff, to your report.
Thank you, Mr. Chair. I'd like to start off by asking if any of the board members have had a chance by roll call to visit the site.
George?
No.
Dave?
Yes.
I have it. Bonnie?
Yes.
Rob?
Yes.
And Ken. There you go.
Thank you. Additionally, has there been any correspondence or communications with the applicant or the property owner or anybody else regarding this request?
I spoke with Mr. Soden. We walked around the back of the house and he pointed out the various components.
Thank you, Mr. Schwegel. Moving on to the request. The applicant is requesting an after-the-fact variance from Section 6.2.1P, Table M of Stearns County SSTS Ordinance Number 422 to leave as installed an SSTS soil treatment area 18.5 feet from an occupied structure and 96 feet from the ordinary high water level of a lake classified as recreational development. Said ordinance requires a soil treatment area to be located at least 20 feet from an occupied structure and 100 feet from the ordinary high water level of a recreational development lake. The applicant currently owns Lot 4 of Block 2 of Baywood Addition. The parcel is in the Shoreland Overlay District of Sauk Lake, which is classified recreational development. Sauk is on the list of impaired waters for nutrients, mercury in fish, and bioassessments. The property is in an R1 zoning district and contains approximately 47,560 square feet of lot area above the ordinary high. The applicant obtained the property in September of 2020. There is an existing 4-bedroom dwelling that was constructed in 1977. The previous SSTS was failed by the owner in August of 2021 under SSTS Ordinance 422, Section 9.2.2L, where an owner can have a compliance inspection requirement waived if the owner acknowledges in writing to the department that the existing SSTS does not meet code requirements. The applicant submitted a septic design completed by Mr. Anderson of Anderson Excavating of Central Minnesota on July 29, 2021, and a permit was issued August 23rd of 2021 for the new system. In the design, it is indicated that the proposed system met all required setbacks. Anderson Excavating of Central Minnesota is licensed with the state of Minnesota to install, maintain, and design systems. Mr. Anderson's certification expires March 17, 2025. An as-built inspection was scheduled by Mr. Anderson for June 9, 2022. During the as-built inspection, ESD staff identified that the SSTS soil treatment area did not meet the minimum required setbacks to an occupied structure or ordinary high of Sauk Lake. At the inspection, while the system was still exposed, ESD staff provided Mr. Anderson the opportunity to reshape and redesign the SSTS soil treatment area and submit an affidavit of incomplete install in a manner that met all required setbacks. Mr. Anderson declined. Sauk Center Township, Sauk River Watershed District, Big Sauk Lake Association, the Minnesota Department of Natural Resources, and property owners within 500 feet have been notified of this request. And alternatives would be to grant or deny the variance as requested based on the findings of fact. If granted, place a condition that upon future identification of noncompliance for the soil dispersal system, it must be relocated to meet all applicable setbacks when a new system is installed. And we have not received any correspondence regarding this request, and that is all I have, Mr. Chair.
All right, to your request.
I'm requesting that we leave the system the way it is installed. Can we bring it up on the screen to see inspection report? This one here. The compliance. Yep. As built.
Is it from the MPCA?
No, this is from Stearns County.
Okay, yep.
Yeah, and we
Yeah.
have it, we all have it. in
Yep,
front of
yep,
us.
we do. Yep.
Blow that up a little bit. Do you care if I go stand up by the screen, anybody?
To be able to hear you, that's the only issue.
Do you have a pointer? Do we still have the laser thing?
Should I just talk louder?
Well, we have to record it for the public record. That's the only reason why. There is a screen over there if that's easier for you to look at as well. And then we do have a pointer if you need to point anything out.
Oh, stand up at the podium?
Yep, there you go. That might help.
Okay.
Kind of wonky, but it kind of works.
There we go.
Good luck.
It doesn't work on screens.
Okay. We got the septic system here. The one end is 99 feet. The east side of that septic system is 99 feet away from the shore. Then we go to the west side, we got 96 feet away from the shore. When I designed this and when I installed this, I used a wheel from the high water mark up to where I had placed the septic, the drain field. And apparently, well, I was a foot off on that one end. And then the shoreline cuts back towards the septic system as you go to the west. And then there is the reason why I did not want to change it is because, okay, we're 16 feet wide from in width, and at 16 feet wide, we're less than 6% slope. So then we can put in a pressure bed. Now, if we go wider than 16 feet, then we're going to be over our 6%. And then that, we cannot use that style. We cannot use a pressure bed, then we got to go to trenches. So, you know, and if we'd go to trenches, we'd have to make them, you know, this I'd have to basically throw away and start over. And if we went to trenches, we'd have to make them shorter, and there'd be more of them, so they'd go up the hill. And I'm going to walk up here and show you where the treed area is and where their access route is to the lake. This area right in here is heavily wooded, right in here. And there is a path coming down by the property line, coming through here, and around here, and it goes down to the lake. That's the only access they have to get like a tractor or a skid loader down to the lake to put in their docks and stuff. Because on this side of the house, there is no room, you know. And on this side here, you can kind of see the path. Oh, no.
Yeah, it's the box that's highlighted.
Oh, yeah, right here. On this side, there is no room in here to come through here with any kind of a tractor or skid loaders. Right through here is where their path is. And if we make them trenches shorter, but more of them, what's going to happen is we're going to come up into here, and then we're going to cut them off from getting any access to this lake shore. And the other thing we could do.
Mr. Chair, we cannot pick up Steve at all for the record. I'm really sorry, but
Okay.
that's not going to work.
Okay. But, and the only other way we could put a septic system in there is we'd have to go to the northwest side of the property, which would be up towards the road. And if we put a septic system up in there, then we got all that piping coming around from the back of the house. Then we got to go all the way alongside the house up to the north side of the property. And this is going to be like 2-inch pipe because it's going to be pressurized. And this pressure piping, the longer the distance, the more it fluctuates with the frost when the frost goes in and out of the ground, and more chances of them having issues in the future.
Any questions for staff or the applicant's representative?
I have a question for staff, Mr. Chairman. It says that the ESD staff spoke with Mr. Anderson out there and told them or suggested it be moved. Where would they move it to meet those setbacks?
Mr. Chair, Member Schwegel, the opportunity to relocate, reshape, redo the drain field when it's open was presented, and we leave that up to the designer to design something that fits within that setback. We don't go out and we're not going to tell them, hey, you need to build it this by this so it meets the setbacks. That's up to the designer to determine. We could sit and try to evaluate the property ourselves and say, well, you could have put this or you could have put that in, but again, we're not in that role of the design.
I guess I just, when I read it, it made it sound like staff said you could relocate it over here and you'd meet the setbacks, but apparently I read that wrong or didn't understand what that meant. So, my mistake.
Question for staff, so I just want to clarify. So the system as it is now, as it's installed, it's in compliance, it's just that it doesn't meet the distances.
That's correct.
Okay.
Anybody else? If not, anyone from the audience wishing to speak to this request, have to ask this. Anyone from the audience wishing to speak to this request? Anyone from the audience wishing to speak to this request? Hearing none, looking for a motion to and a second to close the public hearing.
Mr. Chair, I'll move to close the public hearing.
Motion from George. Second.
I'll second it.
Second from Ken. The remaining goes Dave,
Yes.
Bonnie,
Yes.
and Rob.
Yes.
Motion carries to close the public hearing. Question number 1, is the proposed use allowed in the zoning district in which the subject property is located? Yes or no?
Mr. Chair, I'm going to say yes, septics are allowed.
All right, a yes from George. Dave,
Yes.
Rob,
Yes.
and Ken. Yes for number 1. Number 2, is the variance in harmony with the general purposes and intent of the official controls? Yes or no?
Mr. Chairman, I'm going to say yes. The homeowner's replacing a failing system with one that is compliant.
Okay, yes from Rob. George?
Yeah, I'll say yes with the comment that it's a couple feet off, and so to me there's a degree of variable here. But environmental, a correct septic in my opinion, overshoots everything else.
Dave?
I'd have a question for staff.
Okay.
At the time that they said it was out of compliance, what would have been the change that the staff wanted to be compliant?
Mr. Chair, Member Gamrot, Mark Lateral, Environmental Services. I believe the staff member who spoke to Steve on the phone, Jamie Lucas, I believe, wasn't it, Jamie?
Yeah, it was Jamie.
Correct. And I think what Jamie's suggestion was at the time was to peel a foot or two off the one side of the bed. Yep. and basically do the old cut this off here and add it over here, leaving the balance of the drain field in place to push it away from the ordinary high. I think that was Jamie's original suggestion at that point. So,
But if you take it off the bottom of the system, if you take it away from the lake side and bring it towards the house side, it's just going to be that much closer to the house.
Okay, Dave?
What was the distance to the house?
18.5
18.5.
to the house corner.
So that need to probably been 15 feet or something like that.
Yeah.
Okay, I thought I would say yes.
Okay. Bonnie?
Yes.
And then Ken?
Yes.
Yes for number 2. Number 3, is the variance request consistent with the comprehensive plan? Yes or no?
Mr. Chair, I'll say yes. Having a compliant septic system is consistent with the plan.
Okay, a yes from George. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Ken?
Yes.
Yes for number 3. Number 4, is the property owner proposing to use the property in a reasonable manner not permitted by the official control?
Mr. Chair, I'll say yes on that one because the owner proposes to use a septic system.
Okay. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number 4. Number 5, is the plight of the landowner due to circumstances unique to the property not created by the landowner? Yes or no?
Mr. Chair, I'll say yes. There's limited space to put a septic system in there as explained by Mr. Anderson.
Okay. Dave?
Yes.
Bonnie?
Yes.
Rob? Ken? Yes for number 5. Number 6, will the variance maintain the essential character of the locality? Yes or no?
I would say, Bonnie Mossman, I would say yes, it does. after hearing Mr. Anderson's explanation, I always think of these after fact, that if it had come to me as a before the fact request, hearing this, I would have approved it, hearing his explanation. So I'm going to say yes.
Okay, yes from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes, for number 6. And then number 7, the need for the variance involves more than economic considerations, yes or no?
Mr. Chair, I'll say yes, it does involve more than economic considerations because of the lay of the land and the space.
Okay, Dave?
Yes.
Bonnie?
Yes.
Rob? And Ken?
Yes.
All questions being answered in the affirmative, I would look for a motion to approve this variance.
Now, before we do that, there was something that the staff talked about, the owner signing a document that they would put it in compliance if they ever had to redo the septic system.
Mr. Chair, Member Fiedler, I believe the suggestion for the condition was that standard is that once a variance is granted for a situation or a relief, that variance could be utilized again in the future to replace the same in the same location. With this request, I think the suggestion by the department is that this is a one-time variance, that if this drain field would fail at some point in the future, that the replacement system not be allowed to utilize the variance if granted tonight, that it would be required to meet all setbacks in the future.
So do we need to have that in the motion?
Mm-hmm.
Correct.
Okay, I don't know if I'm going to say this right. I'll make a motion to approve the request for the septic as it is, with the caveat that the variance can't be used in the future to replace it. Is that the right wording?
Okay.
Okay.
Second.
I'll second.
From Bonnie. Dave?
Yes.
Rob?
Yes.
And Ken? Yes. All answers being in the affirmative, this variance is approved. Thank you. And then you're going to get, okay, thank you, Angie.
Have a good night.
Do you want me to reread this, or no, since it was read already?
I don't think you need to.
Okay, thank you.
So, Todd, that's the chair, Jacob speaking, so he's going to take over, okay?
Yes, ma'am.
Okay, to staff too, can I get his address first for the public record?
Name and address.
Name and address for the public record, if you could, sir, please.
38463 County Road 1.
Thank you very much, and staff to your report.
Thank you, Mr. Chair. I'd like to start off by asking if any of the members have visited the site by a roll call.
All right, George?
No.
Dave?
Yes.
I did. Bonnie?
Yes.
Rob?
Yes.
And Ken?
Yes.
There you have it.
Can you guys give me 1 minute? Just because they're cutting out, I'm going to try to put an earpiece in and see if I can hear you better, okay?
Okay.
Hang on. I just don't want to listen to anybody say anything. If it works, as I said, outside.
No, we hung up on
Oops. So do we just wait then, or?
I'd like to.
Okay, yep, no worries.
He has reasons why, which I don't want to share.
Nope, that's fine.
Can you hear me now?
We got you, Todd.
All right, I got here. Now, can you hear me?
Yep, just speak.
Oh, okay,
Just speak clearly.
I'm just going to speaker then. I just could barely hear him.
Okay. All right. Third time's the charm.
Maybe.
that is about embarrassing as there can be right there.
All right, we can hear you real good.
All right, I could, yeah, all I could hear is a muffle. I could barely ask, I could just barely hear him ask for my address, so that's why I said.
Okay. Sounds good.
So I can hear you perfectly. It's just
Oh.
them I can't.
Okay, we'll just remind the board to speak real clearly into the microphone, and if this whole scenario doesn't work, then we will have them go through the meeting without your comments, and I'll just call you and we can try to get through it that way.
Yeah, no, that's great. I mean, best I can help you guys, and I appreciate for what you're doing right now.
Okay.
All right, staff, to your report.
Yeah, were there any communications with the board members, with the applicant or anybody else regarding this request?
I spoke shortly with his wife when she returned from work, and
okay,
that was it.
Thank you, Dave. That we'll add that to the record. The applicant is requesting a variance from section 9.9.9 of Stearns County Land Use and Zoning Ordinance 439 to add a roof-mounted solar array to an existing structure that is 98 feet from the center line of County Road 1, which is classified as minor arterial. Said ordinance requires a 120-foot setback to a road classified as minor arterial. The applicant owns 1.6 acres of the north 900 feet when measured at a right angle to the north line of the east 233 feet of Government Lot 3 west of the center line of County Road 1. The dwelling was built in 1967 according to the assessor records, which is prior to official controls of Stearns County. The existing subsurface sewage treatment system that services the dwelling was inspected in August of 2021 and determined to be compliant by a licensed septic professional. Brockway Township property owners within 500 feet have been notified of this request. And we've received no correspondence, and we have no alternatives or recommendations for this request.
All right, applicant, to your request.
I'm listening, sir.
Okay, Todd, so now's the opportunity for you to add anything you'd like. What you told me earlier on the phone is the solar company was supposed to be here representing you and they didn't show up, but you did not want this to be continued. So,
no, I didn't. I actually, after me and you hung up, I called every party that I have a number for the solar company, and I even called XL because they've all touched base with me about waiting for this variance.
So other than the request, Todd, that is you're requesting to add the solar panels to the roof that happens to be,
yes,
do you have it?
Of my existing home that I don't want to put it on the ground because there's a snowmobile trail here and everything, and I'd rather it be on top of my house so I don't have to worry about an accident or somebody like going through my backyard on a snowmobile and hitting a solar panel. That's why I really wanted it on top of my house.
Okay.
Last year I did have multiple snowmobilers that went between my house and Joe's excavating for some reason flying through the back of my yard. And, they're like, well, we'll put them underground. And I'm like, no, because I don't want to have an accident. So, and I don't know why they're going through the back of my yard till this day. So I've actually brought that up with the township.
Okay, do you have anything else to add at this point?
No, ma'am, I don't. I mean, unless they want something from me, I mean, I'll do whatever you guys would like me to do. I've been trying to be, to the most of it, whatever you guys want.
Okay, just hang tight and we'll see if they have any questions for you.
Thank you, ma'am.
Any questions for the applicant or staff at this time from the board members? There appears to be no question from board members. Once again, I'm forced to ask the question. Is there anyone in the audience wishing to speak to this request? Anyone in the audience wishing to speak to the request? Anyone in the audience wishing to speak to the request? Hearing none, looking for a motion to close the public hearing. So I need a motion and a second, please.
I do have a question for the staff. So if it weren't for the distances, the setbacks, there would be no issue with this, correct?
Correct.
Okay, thank you.
All right, motion and a second needed, please.
I'll make a motion to close the public hearing.
Motion from Dave, second.
I will second that.
Second from George. Bonnie,
Yes.
Rob,
Yes.
and Ken.
Yes.
All right, that is approved now to close the public hearing. So now moving to our finding of facts. The proposed use is allowed in the zoning districts in which the subject property is located, yes or no?
Mr. Chair, I'm going to say yes, it is allowed.
All right, Dave,
Yes.
Bonnie,
Yes.
Rob,
Yes.
Ken? Yes for number one. Number two, the variance will be in harmony with the general purposes and intent of the official controls, yes or no?
Mr. Chair, I'd say yes, this is, for me, this is kind of similar to the other one. The distances are minimal.
Dave,
Yes.
Bonnie,
Yes.
Rob,
Yes.
Ken?
Yes.
Yes for number two. Number three, the variance will be consistent with the comprehensive plan, yes or no?
Mr. Chairman, yes, it'll be consistent with the clean energy policies number 5 to encourage the development and use of renewable energy systems throughout the county.
All right, a yes from Rob. George?
Yes.
Yes from George. Dave?
Yes.
Bonnie?
Yes.
Yes from Bonnie and Ken?
Yes.
Yes from Ken. Number three is a yes. Number four, the property owner proposes to use the property in a reasonable manner, yes or no?
Mr. Chair, I'll say yes. Having solar panels is a reasonable use.
Okay. Dave?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Ken?
Yes.
Yes for number four. Number five, the plight of the landowner is due to circumstances unique to the property, not created by the landowner, yes or no?
Mr. Chair, I would say it's unique to the property because the house was built before official controls.
Okay. Yes from Dave. George?
Yes.
Bonnie?
Yes.
Rob?
Yes.
Ken? Yes for number five. Number six, the variance, if granted, maintains the essential character of the locality, yes or no?
With, after seeing the property with the number of trees around and looking at what's behind it and the other homes, you're not going to really see it at all. So I don't think it's going to change the character.
Okay. Yes from Bonnie. George?
Yes.
Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
Yes for number six. Number seven, the need for the variance involves more than economic considerations, yes or no?
Mr. Chairman, I'm going to say yes. Economics aren't playing a role in it.
Okay. George?
Yes.
Dave?
Yes.
Bonnie?
Yes.
And Ken?
Yes.
Yes for number seven. Therefore, all questions being answered in the affirmative, I would look for a motion and a second to approve this variance request.
Okay, Bonnie Mossman, I move to approve the request for the solar panel 98 feet from center line of the road.
All right, a motion from Bonnie. Second, please.
I'll second.
Second from George. Dave?
Yes.
Rob?
Yes.
And Ken?
Yes.
All board members voting in the affirmative. The motion is hereby passed and your variance request is granted. Therefore, since we have finished our variance business for the evening, the minutes will just move over until next month, correct? So we have no minutes for us. Do you know how many items we have on the August 25th agenda as of yet, or is it closed? Hasn't closed yet, has it?
Mr. Chair, I believe we are at 3, but we haven't officially noticed them yet. So
okay.
The last I heard, we had 2 from the land use and 1 feedlot variance, but I haven't heard the final list yet. We'll know more in a couple of days.
All right.
Deb
Okay.
said the same. So yeah, it sounds like it's going to be 3.
All right. Anything else for the good of the order? Hearing none, motion to adjourn the meeting? Unless
Yes.
Angie, did you have anything? Okay.
I so move.
Motion from Dave, second.
I'll second it.
Meeting is adjourned.